Welcome back, everybody, to our lessons in easements for land law. This is, in fact, our final lesson specifically on the acquisition of easements. And we're going to be talking briefly about the requirement for prescription of easements. So we noted in the previous lesson what prescription of easements essentially happens, how it happens, how it could happen, either through the common law, through the loss of a modern grant, or through the 1832 Prescriptions Act. Depending on which of these of the three modes of prescription one chooses to explore, there will be requirements which are necessary for you personally for all three. And this is really where we get to the requirements for prescription. In order for an easement to be granted through prescription, the user must be, firstly, as of right. They must, secondly, be continuous. They must be, thirdly, must be by or on behalf of a fee simple owner against another fee simple owner. And these are the three major requirements. Now, what do these things actually mean? What do we mean? What do you mean? I have to be as of right. I have to be continuous, and I have to be on behalf of or by a fee simple owner against another fee simple owner. What do all these things actually refer to? Well, let's begin with as of right. To show that the use of an easement is as of right, it must be shown that they are not users by force, by stealth, or without permission. Those are the three ways in which the three requirements that are satisfied for proving that you are as of right. The burden of proving this rests with the person who is claiming the right. I'm claiming that I have a right of grant of an easement or prescription of an easement, and as a result of which, in showing I have this right, I have to show that I'm not a user by force, by stealth, or without permission. So you have to prove that you are acting without force, you are acting without secrecy. Here, a reasonable person ought to be able to discover the existence and the exercising of that right. That's what we mean by secrecy or stealth. And then finally, the user must not depend on the permission or consent, whether this be oral or written. So these are the three requirements for the idea of establishing yourself as of right. We have three nice little Latin pieces of phraseology to sort of help us along our way in making a determination on this, and this is how we make this determination specifically. Secondly, we have to show that the right or the enjoyment is continuous. You must be able to show that your right has been continuously enjoyed. This is to be judged on the basis of what a reasonable person might consider to be continuous, might be considered to be continuous use or enjoyment of that right. That is the case as cited in the case of Mills and Silver. So fundamentally, what we're seeing here is a reasonable person test. Does a reasonable person acting reasonably with a reasonable basis of knowledge suggest here and know that you are continuously enjoying the right that you are seeking prescription of? This does not mean, however, that there is no opportunity for there to be breaks in the use of enjoyment. Continuous enjoyment isn't necessarily that strong of a phrase. It is just that on the whole, there is a mode of continuous enjoyment. So you can allow for there to be breaks in the enjoyment of the land, of the right, should I say, but it doesn't necessarily have to be continuous in the sense that it is always enjoyed, and even a break in that enjoyment for a day would mean that it breaks this idea of being able to grant a prescription. That's not essentially what happens. Finally, then, the final requirement for you in proving and being able to essentially get an easement through prescription is you have to be by or on behalf of a fee simple against another fee simple. The claimants must show that they are either the fee simple owner of the dominant tenement, or that they are claiming the right on behalf of the fee simple owner of that dominant tenement. So, for example, if it is being claimed by the tenant of the property or something like that. Again, this is relatively uncontroversial. There's not much to be said about this. You have to either be the fee simple owner of the dominant tenement or claiming on behalf of the fee simple owner of that dominant tenement.